Visa Bulletin.
February
And
Visa Bulletin, Sam.
February Visa Bulletin, Brian. I was just testing if you're focusing on this,
I'm 100% zeroed in. I
which
almost
is
said it before you did.
yes, which is a not much of an improvement from the January Visa Bulletin, but we will get into that in a moment. Um, as quick introduction, my name is Sam Shihab, and I am a partner with the law firm of Shihab Burke, and with me,
Well, I'm Brian Burke. I'm a partner with this firm as well, Shehab Burke. We are based here in the Columbus, Ohio area, Dublin specifically. If you're close by and want to find us, we practice employment immigration law as well as some family immigration law. And it's my saying, Sam, is that it is Monday. It is 6 p.m. and it's not a holiday. Thus, we are here talking. Actually, it is a holiday, Sam. What am I saying? It's a federal holiday, Martin Luther King Day. But this is one where we usually work, and thereby we are here talking about important immigration matters for the benefit of our audience. And
and it is the February Visa Bulletin. We're going to talk about it. We're going to talk about a few other things, and then do the very important piece of taking questions and answering them. That's our favorite part of the presentation, and I think probably a lot of people also enjoy that part.
yeah,
But Brian, February Visa Bulletin, uh, well, predictable.
predictable with a little bit of surprise on the EB3 India front, where fundamentally what we really look at on most of these visa bulletins is EB3 and India, because or rather India in general, because that is the most backlog category. That's where the most interest and excitement is, people waiting so long for a green card. And I'm going to go ahead and put it right up on the screen right now, the January visa bulletin, as well as the February synopsis, final action dates, of course, both and dates for filing and final action dates, so we can see what the big difference is here. Um, so there it is, and there we are down here. There's the January 2024 Visa Bulletin, and I'm going to ask everybody to pay attention down here to the EB3 final action dates here for India, because that's what's going to change. And there it is. EB3 India final action dates have gone ahead 1 month, from June 1st, 2012 to July 1st, 2012. And Sam, I just want to point something out to everybody. I've had a lot of emails, more than I expected, saying, "Hey, Brian, my priority date's current now for the February Visa Bulletin. What's next?" Which is kind of what prompted the topic of our conversation today. It's February Visa Bulletin and what to do now that my priority date is current. But one of the things I feel it's necessary to highlight, Sam, is why there might be a bunch of people with shiny new current priority dates across the month of June 2012. It's because I was just thinking about this. It's perm prevailing wages. Anytime you do a perm process, you get a prevailing wage that's valid until 6/30 of a given year at a maximum, right? And I know that in our office that perm filings deadlines hit in the month of June. A lot of
Otherwise, the prevailing wage expires and you got to start all over again.
Yeah. So I imagine, and maybe I don't know if the Department of State was thinking about this when they moved the dates, but there is probably some decent density of I-140 priority dates within the month of June 2012. Because I think if I had to make a guess at what is the most priority date dense month in any given year, again, I've never thought about this before. I would say it has to be June for that reason. Would you find that to be crazy, Sam?
I don't find it to be crazy, but it is cute piece of speculation, to say the
Pure
least.
pure speculation. Well, Sam, I just
You know,
happened to notice
yeah.
that I got a
Mhm.
surprising amount of emails saying, "Hey, Brian, my priority date is current. Now what's up?" But
So what you're talking about is so moving it to July 1st really included a bunch of people.
uh,
That's what you're saying.
well, okay. You're right. I am speculating, but it has the potential to be a bunch of people because I do believe that it is highly likely that in terms of picking a calendar month of any given year, if I wanted to gamble on it, I would say the most priority dates are going to be in June, for the fact that that's basically the way the perm process works. It's when prevailing wages expire, and it's when there are hard deadlines to file perms. Maybe there's a little bit more density in May as well, but if I had to pick one, I would say June. And
Well, Brian, all right. So here's the piece that I want your thoughts on.
okay, I'll give you thoughts on a bunch of other stuff too, Sam. Just to
I
let you
know
know.
you will. I know you will. But here's the piece I want your opinion on.
Yeah.
Um, if any of that date has come and passed before, I believe.
Yeah.
So these people, maybe it's not the first run on that being visa available for them,
Yeah.
right? Some
Yeah.
people, before it became current, they got excited and then it retrogressed on them.
Yeah.
Would you ask them? Would you recommend to file for writ of mandamus on day one for these subgroup of people?
Yes. Is the bottom line. And we've had this we're always talking, people ask us all the time about, is a writ of mandamus a good idea, bad idea? What's the timing? And I am pretty conservative in the way I approach this, but this falls in the category, fool me once, shame on you. Fool me twice, shame on me. I got the saying right this time, Sam.
You did get it right. Continue explaining. I'm going to improve the lighting in my office and I'll return in a second.
Okay. So basically, the idea, concept for those, to a bit of a refresher, the idea of a writ of mandamus is basically suing the government to get them to make a decision on your case because it's been taking too long, essentially. And for somebody with a long pending I-45 case, somebody who filed in, say, October 2020, I think that if their priority date becomes current now, I think they kind of have to have a compelling case for forcing the government to act now. Why? Because, I mean, just think about it. Your priority date was current at least once in the past when, for the vast majority of people, of anybody who has a priority date that's current now, their priority date has been current in the past. If your priority date was current in the past, a lot of people who have priority dates that are current now, well, they still have, they have, if you have a priority date that's current now, odds are it was current a second time. And honestly, what you're looking at right now is probably the third time your priority date's been current. And you've had your priority date current at least twice. They didn't make a decision on your case, and I think it is fundamentally foolish at this point to trust the government to act timely on your case, um, and prove your case now before your date retrogresses again. Um, well, I guess so the very long rambling answer short is you've been burned at least twice before. What's to think you're not going to be burned again if you don't get a decision immediately? I guess that's a question, Sam. Do you think?
So
Go
yeah,
ahead.
so you do just go to court, or you will also contact the congressman? I think a congressman won't touch this with a 10 football. If there's a court case, the congressman usually they're the
Yeah,
first people to just say, "Oh, lawsuit, we're not going to get involved." So that one is out if you're going in that direction. But I think it doesn't hurt to write an adjudicator's letter.
yeah, sure. Well, sure. It's believe me, court cases are like a bit of a last resort. But maybe your letter. Typically, in the past, Sam, maybe like 6, 7 years ago, we'd write a polite, simple adjudication letter. Hello, government. My priority date's current now. Please adjudicate my case. And they would typically act pretty fast on those. But I would say the idea of a letter to a precursor to a mandamus action is pretty good. And you know what that letter would say, Sam? At least in my mental draft here, it's one, please adjudicate my case. Give them a time frame and let them know, if you don't make a decision on that time frame, I am going to be filing a writ of mandamus in federal court. And
And a reminder: this is the second time my party date, or third time my party date became current,
yeah,
and I am relying on your quick action to avoid an embarrassing fourth time of
yeah,
delay.
yeah.
Yeah, and
Again, I don't like. I don't. I generally believe that the government they're not, maliciously not trying to approve people's cases. They approve people's
no
cases
question.
because
Yeah.
they ran out of visas. But
There's no malice. There's incompetence, Brian.
yeah,
I
don't
don't
you?
I don't know
Yeah,
which is worse. I mean, there's no malice, but there's definitely incompetence. I mean, yeah.
yeah.
I mean, yeah.
And so, well, I guess Sam. Do you think that we're likely to see big retrogressions anymore at this point?
I think the State Department is being very careful
I would
not to
agree.
move forward, um, and they're basically to avoid retrogression.
I would tend to agree with that. Then again, we
Well,
had a
I'm not
bit.
sure. I'm not sure which system is better. Both suck. I'm sorry to say that. It's
Yeah,
horrible
yeah,
because if you move forward in retrogress, at least you get an EAD, an adjustment of status,
yeah,
advanced parole, and you have options, right?
yeah,
And if you don't move forward at all, maybe you don't retrogress, but you're not
yeah.
getting these benefits. So which one is better?
I would say, well, people who have pending green cards right now sure do prefer the world where they have that in lieu of in lieu of that, you know, in lieu of having nothing. But gee golly, I guess what I would say is that the people who have had long pending green cards and have seen people, friends, colleagues, etc., get a green card with a later priority date than them, they're driven absolutely mad as well.
Yeah.
So, that's something. I don't know, Sam. I think I'm just left to be inclined to agree with you that both systems kind of suck, for lack of
Yeah.
a
I mean,
better.
it's just non-availability visa that will continue to haunt us for time into the future that we do not know how long.
Yeah.
And that's basically what we got. We
So
we do we do see a friendlier administration than the previous one. There's no question about it. Approvals are high, RFEs are low. Things are moving within their very limited uh, capabilities, but we do not see. And again, maybe until a second term, we do not see bold moves to resolve big problems.
yeah,
Like Obama's. He said, "The hell with it. I'm doing DACA." Boom. You
yeah,
know, I'm handing those guys employment authorization documents.
yeah.
When you came here, you're a child. I'm gonna give you an EAD. So
So
yeah, there has to
yeah,
be something where they come out and say, you know what, you've been waiting more than 6 years, 7 years. I'm
yeah.
gonna do this. Party date is more than if your party date is retrogress more than 6 years, 7 years. File your adjustment.
Yeah.
File.
So
Mhm.
something else I want to bring up. So, Stan, we've talked about what you can do about this. Well, I want to focus in on this a little bit more before we turn to what else can you do. So, if your party dates come up now, you know, you can send an adjudication letter and you can threaten a writ of mandamus in federal court. And I don't think that's crazy at that point, especially for long pending cases filed in
Mhm.
October 2020. Um, additional question related to that is people have been asking. I've got a couple questions about this in my email. It's, hey Brian, I've been jumping categories around. I jumped to EB2 with a transfer underlying basis, and now I'm current in EB3. Sam, what's your take on what to do about that? If you last filed a transfer of underlying basis, right, to EB2, and now you're current in EB3, do you believe that somebody needs to act upon that?
Reluctant. Well, the only action I would recommend, and I honestly, um, I mean, if you're able to file two adjustments but not transfer underlying basis, I mean, I
Oh,
wouldn't.
transfer from, well, so
I'm not
hypothetically,
leaving EB2 to EB3. I mean, the ping pong got to stop.
yeah, but
I would not move. Personally, you may have a different opinion.
well, I mean, so here's my take on the subject. Maybe I do have a different opinion, and I guess maybe the different opinions for different sorts of people. You're right. I would not want to give up. Your best case scenario is exactly what you said. Be filed for adjustment of status in both categories because the ping ponging is back and forth between categories is a nightmare. But imagine somebody right now who, okay, the last I know is I told them I want to change to the EB2 category, right? And now I'm current in the EB3 category, and I desperately want them to approve me in the. I want my green card approved. I mean, does it sound crazy to basically say, fine, move me to the EB3 category and approve my case again? And for me, that sounds like something. You're right,
If you're
Sam.
current,
Yeah, if you're current in EB3,
I mean, transfer underlying basis or new adjustment.
transfer. Well,
Well, yeah, you can't do new adjustment. That'll take a year and a half to 2 years. It'll be a waste of time.
exactly. So
Yeah.
yeah, if you're current right now, I'm inclined towards putting in a transfer of underlying basis and saying adjudicate my case. Now, Sam, do you think you can do a transfer of underlying basis, then file mandamus action?
Yes.
I agree. And
Yes, you
again,
can. Yes, you can. Probably that would be a good solution, Brian. I always know you of a person who think out of the box, and that's a great solution and an excellent approach, because it could end up being a green card,
Yeah.
or you can just wait.
Yeah. I mean, that's the thing. No matter there's versions where
I
people
agree. I
people
changed my opinion.
okay, well, people are always. I mean, the bottom line is, no matter what, right now, if you have a long pending green card case, fundamentally, it doesn't sound. Mandamus actions are where it's at in my mind. And Sam, I'm surprised by the things that are coming out of my mouth. Oh yeah, file a transfer underlying basis and immediately file a mandamus action. The Brian who says that's crazy says, well, you just gave him the information that you want to be in the EB3 category. Why should you be able to file a mandamus action for them moving too slow? And my answer is because they've had this opportunity before. You know,
If they
they've
had,
screwed,
if
they
they've
screwed
had,
you
if you've
over.
had this opportunity before and you missed out,
Yeah.
then you can definitely file for it.
Yeah, I mean, I don't like the costs in having to do the work of doing another transfer underlying basis request. But if you want to be technical, if you want to read the policy, if you want to think about the policy, you move between categories. Technically, I guess you have to move back in order to do it, and it's move back and approve my case. I am very. This is strange for me. I'm just feeling very mandamus happy if you have an October 2020 case because and your priority date's current again. I mean, the more conservative side of me says, well, we think the Visa Bulletin is they're being careful with it right now, right? And we think it's probably we don't foresee any retrogressions. But one, we've been burned by the Visa Bulletin before. Two, I just said aloud here. I bet there's some really high density of case volume in June of 2012. And three, I don't know if you've been waiting this long. I would think you'd want your case filed as your case approved as soon as possible, and more waiting be damned. Essentially,
Excellent point. Before we move to answering questions,
yeah.
let's put in that Ninth Circuit Court of Appeals decision
Okay.
and the quote that we've discussed, which is the last slide of that presentation.
Yeah. Shall I put it up?
Because I have a question for you. Yeah.
Okay, I'll put that slide back up here. There we go, tiny us, and there it
Yeah.
is.
Can you make it bigger?
I don't think I have. I don't think I have the means to. Well, let me see. There's a zoom button here. I might be able to. Nope. I don't think I have the means to easily make it bigger.
All
But
right, sounds good. So let's go ahead and read it. Despite lawful employment in the United States for more than a decade, plaintiff, this is, by the way, in a denial of a case. So it did go for USCIS, but the language here is got my attention.
yeah,
So the court in the Ninth Circuit, I believe as a California court,
yeah,
said despite lawful employment in the United States for more than a decade, plaintiffs still have no clear indication of when their application for a green card will be approved. The long immigration visa queue imposes significant hardship, and plaintiffs are understandably frustrated. But in this instance, relief must come from action by the executive and the legislative branches rather than the judiciary. So this decision takes the step of recognizing the issue, and that's for me a step in the right direction. But of course, doesn't go far enough
yeah.
to rule
It's
in
it's
behalf.
nice for a court to acknowledge it, but they can't. The last half of that is we can't do anything. Executive and legislative branches, the president and the Congress, are the ones who have to fix this issue,
But
right?
here's my question to you, Brian.
Sure.
Um, the court have now acknowledged that a 10-year wait in the United States is a significant hardship. Now, what benefits can we get, hardship-based benefits, for everybody who's been waiting for more than 10 years?
Well, I would think of an extraordinary circumstances EAD if you're pushed into that
That's
category.
100%, right?
Do
I
you,
mean,
do you have something
nothing's
else in mind?
100%, but that's a very significant when they say significant hardship.
Well, honestly, I mean, Sam, I think just in the idea of that, just your mandamus action. Now, we're not in the Ninth Circuit here in Ohio, but you literally have an appeals court saying, "Hey, we acknowledge that waiting for 10 years for a green card is a significant hardship." I'd be citing that court decision in my mandamus action. Even it's Ninth
100%. So
Circuit
we,
is not
we can use
binding.
that in the mandamus action. The Ninth Circuit is I mean, not binding on
Not
the
binding
Sixth
on
Circuit,
us, but
but
it's
informative.
compelling. Yeah.
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 Um,
If you're really trying to quickly educate your local district court upon this, I'd say check out this interesting decision from the Ninth Circuit. This is an active issue, and appeals courts are handling it, and they agree that just the 10-year delay alone is a significant hardship. And you know what I again a good mandamus action, Sam, and I'm going to put us back here on the big screen. It's just a layer of telling a good man, making a good mandamus complaint is telling the different, kicks in the gut or the teeth that you've gotten. It's, I've had my priority date become current multiple times before. I have family. I'm losing job opportunities. I'm literally, my parents are getting old, and they're in my home country, and I can't sponsor them, but I might have been able to because I would, if I were from any other country on the planet, I'd be a U.S. citizen by now.
yeah.
You know?
And a lot of people were talking about all this EB1 filing is going to be pushing down the application. But all what we're seeing is a lot of EB2s filing for EB1 recently, and the
Yeah.
success we've been having with the EB1.
Yeah. I mean,
Yeah.
I'll put it out there because there's somebody in my inbox right now who I have to respond to give a a
Mhm.
thumbs up. But we're still talking to people about EB1As, and we do them on a freebie basis for people. So
Evaluation.
yeah,
You're
evaluation.
not going to file those cases for free,
I'm
Brian.
not gonna no, I'm not gonna
I got a
file
lot
those
of
cases.
people here that would like to use you as an
Well,
attorney.
yeah, if we're filing them, that's the wrong one. If we're filing for free, no, I think we'd have a serious business issue to talk about. But
But what we're seeing is people from the EB2 moving to the EB1.
yeah,
So I think it's not weighing, as a matter of fact, maybe improving the EB2 a little bit,
yeah,
and maybe pushing down the EB1. But I think in the balance is about the same. But this may be, if the Trump administration takes over next year, which they're ahead in the polls right now, this may be the
yeah,
last year for the
yeah.
EB1 in a long time, in maybe a decade.
Well, yeah,
You never know it when it comes back again.
yeah, I guess my take on that is people who are super, they're not gonna change, touch wood, they're not gonna change the law, at least they won't be able to do it immediately, change but the people adjudicating cases will change, and people who are more edge cases now who might get approved just, on the edge, those cases, I imagine them not being approvable in the future, and that's the interesting
The
part.
EB1 law hasn't changed in two
Well, yeah,
decades,
yeah,
and it's not going to change. And it's not about the law changing; it's about
the
what
people
they are
who are,
willing to approve and what they're
yeah,
willing not to approve. What is 100% approvable today is 100% deniable a year from now potentially, and not vice versa. It's that in that order.
yeah,
So if we have a different administration, so
yeah,
yes, if you we are doing still, Brian is confirming we're still doing no cost evaluation.
yeah,
You just email us to
and
this
say
email
hello,
address
yeah,
and request. We have a smart form that we send that collects some information from you, and then we submit that. It gets evaluated. If the case is promising, we'll also get on the phone and talk to you.
yeah. I would
Mhm.
encourage everybody to just, if you're feeling bored, spend a little bit of time. Google the USCIS EB1 criteria. It's available freely there
Very
on the
well
internet.
written. Yeah.
Yeah, there. If you think if you think you might stand a chance, it's probably worth talking to somebody about.
And our time to answer questions.
Is upon
This is
us. Yes.
this is when we tell you that we are going to answer your questions to the best of our abilities. We do not know enough about your case except the 4 or 5 lines you drop in via the either Facebook or YouTube or whatever medium you're using, and we will do our best to answer it. But do not rely on it. Do not. You really need to consult with an attorney to be able to understand your case fully to make a decision on your case. Like the government says, don't sell your house because Brian said something.
Well. Brian's gonna be the first one to say, don't buy your airline ticket until the visa's in hand,
Exactly.
etc.
And there's no attorney-client relationship established because we're answering questions. But without further delay, Brian, let's take the first one.
Yes. Let's see what we got here. Bing, there it is. And I'm gonna have to do what I always do, Sam, is massively zoom in my web browser so this thing becomes readable. I miss having the widescreen that we have in the conference room, Sam. So, from the Ms. Paresh, Have GC interview for EB3. Perm shows job location is office in Ohio, but I work from home in Ohio, which is 25-mile away, and will continue to work from home after green card. Will it be an issue if I say work from home as my GC work location in the interview? So, Sam, you just made a beautiful statement about we don't know the details of your case, and this question for me kind of illustrates why. I think my first answer for this individual would be uh, really depends upon the details of your labor certification that underlies your green card application, and maybe that's my honest answer. It basically, for those who aren't aware, your labor certification says where you're supposed to be working, and if in your I-140 will reflect the same, and that's what really govern what your answer needs to be for this.
So until unless you look at the labor certification, you really cannot advise this person precisely.
Yeah,
How it is drafted is going to dictate what is the answer, right?
yeah, but then again, I mean, again, the devil in the details. Let's say hypothetically, um, it said, well, this says an office in Ohio, but the work from home, it's in the same MSA. 25 miles away, it can potentially be in the same MSA, right?
Maybe, maybe not.
Well, I get that, and that's why
Ohio?
you look in the case.
Yeah, that's exactly.
That's why
Yeah,
you look in the
yeah.
details of the case. I mean, I think of other options, Sam. If it is a problem, one might be able to file a supplement J, for example, and basically a change in the offered to offer your employer offers you a different job that allows for that. But again, I'll come back to the beginning and say the devil is in the details about
Yep,
what is really in that case.
yep.
You know. Well, Sam, this one is from Rami Love, and
Good evening. What are the chances of EB3 August 2nd, 2012 India becoming current in the next quarter with USAS allocating numbers quarterly? So the EB3, as you look up the dates, Brian, just I'll give you a quick introduction, is not going to benefit from any unused EB2s that goes
yeah,
down to it. So EB3 will have to survive on its own. August 2012, I think that's beyond the dates for filing, if I
it
remember
is
correctly.
one day, literally, Sam, one day before one day beyond where the EB3 dates for filing are at right now.
Hmm.
So what we talked about is
And that's
basically,
and that's why the question, I guess.
yeah,
The question is
yeah.
a smart one. So yeah, go ahead. What does that mean? August 1st, 2012,
Well, right now
2012.
we
Yeah.
are 1 month between 1 month away from the final action dates are 1 month away from the dates for filing, and we our sort of theory that we discussed in prior sessions is that essentially that they should put a dates of filing date that's out there a little bit, and the final action date should catch up to that. And the question we have is really, is that happening over the course of just quarters, or is this August 1st, 2012 going to move at all within the next fiscal year? And my short answer is I don't think we have answer to that. I think we are kind of in learning mode still about how whoever is managing the Visa Bulletin now for the Department of State is actually managing it.
Well, clearly, the previous folks were thinking that um, the that Visa Bulletin is going to be reaching the August 1st date in this case by October 1st, right?
Yeah, they usually said 8 to 10 months. Yeah, yeah,
Um, yeah, so
yeah,
it's always 8 to 10 months out.
yeah.
So to me, that's an indication that it is not in the next Visa Bulletin,
Well,
at
yeah,
the
not
very least, to answer the question.
yeah. That's a very. So my honest answer for Rami Love is I think we'll figure it out on the next Visa Bulletin, and what kind of math they're applying. I don't think it's crazy considering there's only a month between dates for filing and final action date. There's another Visa Bulletin between now and the next consequential one in April, and my mind wouldn't be blown if it turns out that dates for filing move, because we're still learning about how they're currently managing it, but we'll just have to cross our fingers for you for the
So,
time being.
just information. November 2023. I went back to November 2023
Yeah,
to test our theory.
yeah,
Um, final action date for India
Yeah.
was May 2012, and the date for filing India was August 1st, 2012, unchanged. So that date has been holding since
Since
the
the beginning of this
beginning of the
fiscal year.
fiscal year,
Yeah.
which tells me um, probably that's the outlook. And if I look at
I guess
October,
so. You're saying this, Brian? This number, this August 1st, 2012, has held true across 2 quarters, essentially. The one starting in on November, and the one starting in January, right?
yes, and
Yeah.
for October, just to let you know, the dates for filing
For
was same August 1st, 2000. That date hasn't moved in a long time. That
yeah,
tells me that they don't think in the foreseeable future they're going to cross that date.
yeah,
At
yeah,
least the way they look at it now. But they look at it every quarter seriously.
yeah.
Um,
I get. Yeah, it doesn't sound crazy that I mean, again, that Rami Love's date could be current in the near future. But
yeah,
if I have to read this, you're right. The bottom line, August 1st, 2012, is the foreseeable future, and that's your date is
that's
one.
the ceiling that we have now.
Yeah,
Beyond that, even the State Department does not have visibility, I would say.
yeah, yeah, yeah,
So no, it will not be,
yeah.
in our opinion.
We have another Visa Bulletin related question here from Naz. Sam, you want to go ahead?
Is there any possibility of EB to rest of the world filing date moving to June 2023 during this fiscal year? So again, same analysis, right? So
Yeah.
since I got the October Visa Bulletin right now in front of me, might as well looking at that
Oh
rest
yeah.
of the
I will
world.
I will mention first by starting that currently the EB2 rest of the world final dates for filing are in 15th of February 2023. That's for the February Visa Bulletin. So where were they at in October, Sam?
In October, Brian, for dates for filing for EB2 rest of the world
Yeah.
is January 2023,
It's January. What date in January? Out of
January
curious.
1st.
January 1st. So it has moved. See, this is this is why it makes it. It has moved a month and a half since the beginning of the
But
fiscal year. This.
if there's any, well, that was October, not
Yeah.
November. I'm going to look
Yeah.
at November. But the rest of the world is the more likely to move, and therefore I can accept that.
Yeah.
But dates for filing in November was January 2023 as well.
Yeah.
Yeah.
So I
So
don't know.
there's slight movement, but the movement is not in line with that big jump that's being proposed here, which is
Yeah.
June 2023.
Yeah.
So I'm not optimistic. Let's put it that way. What
I
do you
would
think?
tend to agree with you on that one.
Yeah.
Based upon what we're kind of going back to, I just don't foresee any big movements on the Visa Bulletin unless they correspond to big visa availability.
And we're using knowledge from the previous administration that was running the Visa Bulletin and the new one in reading minds, really, and interpreting some logic. There's not much to it in our recipe, right?
Yeah.
There's no complicated law involved here in our
Just seeing where it's been and trying to,
yeah.
yeah, yeah, yeah.
All
So
right.
let's see what we got on the next one from a frequent viewer here, Sky Limit. Hello. For the pilot program, I do qualify, but my visa expires in July 2024. Can I apply for new visa with H-1B? New visa with H-1B extension, even if my old visa is valid for a few months. Also, have a new passport. So, Sky Limit is talking about the H-1B stamping inside the United States pilot program. With an H-1B, I'm having trouble sort of separating everything out here. I think basically somebody's. I think what he is saying is his current H-1B approval expires in July of 2024, and I'm maybe trying to can I one get an extension based upon the extension based upon a new H-1B extension that I would file, and if my old visa, if my current visa is already valid. So, H-1B
So
pilot program.
issued by Mission of Canada. Let's go
Yeah.
over them between January 1st, 2020 and April 1st, 2023.
Hmm.
Or Mission India, February 1st, 2021 through September 30th, 2021. So I'm assuming, and they're not subject to the non-immigrant visa issuance fee. Um, um, File for waiver. Um, Tend to enter the United States or issuing visa applicant period. Let's see here. So 4,000 application slots available for the following as follows: January 29th to February 5th, and then February 12th. And yeah. Well, I don't have the rules committed to
Well,
memory. So
yeah,
I'm trying to
I
parse
guess.
it. Yeah.
Yeah, I'm sort of parsing through them myself as well. And there's like those 12. I'm looking at the Federal Register as well right now.
Mhm.
And what I'm not seeing is any requirement that your present H-1B visa is not expired. You know that.
Mhm.
So for me, that's the challenge. The challenge there. And the other requirement on the list is have an approved and unexpired H-1B petition. So basically, for me, it doesn't sound like there's any problem with the fact of adding another H-1B approval on top of that.
So,
Um,
so are applying within 48 months of their most recent non-immigrant visa expiration date. That's the only thing.
well, okay. So that is on the list. So Sam, call me
Yeah.
crazy. That seems to require a visa expiration.
Yeah, a stamp.
Yeah,
Yeah. Applying within 48 months of the most recent non-immigrant visa expiration date.
yeah. So that requires your prior visa to be expired. Then taking that at face value, right?
Yeah. So that needs
Meaning,
to be obviously sky the limit. We need to. This is the kind of thing that you need to lay it out. Lay out all the rules on one side and lay out all the requirement
yeah,
on the other side. And that probably not something we can do with
yeah,
you online right now.
yeah, yeah,
And then the remedy you're proposing, I don't know. So let's take
yeah,
the next one, Brian.
yeah. So, well,
Sorry, Sky. The limit, we couldn't help you.
yeah. Well, another question from Sky Limit, but also on a totally different subject there. Can I open my business using EB5 based EAD and not work there, but keep my H-1B status while working at my current job? So,
Simply, yes, but the question is, he's required to run the EB5, and I lost some light here, but I think that even he's required to run his business unless he's doing a part of the pilot program.
I'm gonna sort of answer this question very simply with a no, because the question is, can I use my EB5 based EAD and keep my H-1B status? The answer is no, because
Well,
that
he did not say, can I open my business
using
using
EB5.
EB5 based EAD and not work there, but keep my H1B status while working at my current job?
I
No,
see.
I think you're reading of it. Now I'm reading it your way, so that's
Yeah,
hard to understand. So yeah, well, to open let's explain it in
yeah,
English. To
yeah,
open an EB, to run an EB5, you're required to run that business.
yeah. I mean, it can be pretty high level, but I mean, he's talking about using the EB5 EAD to get it going. And for me, it sounds kind of like work to me. Would be my general
So
answer.
how far is it not work? So let's assume he hires somebody to do it for him, and he's just hiring lawyers and meeting to set it up and accountants. Does that work?
Uh, I mean, the EB5 still threshold for managing the business is pretty low. Yeah, as I recall, you have to have like managerial authority over the business. So
Authority or actual work?
I would honestly have to go ahead and check the rules on
It's
that.
difficult to do that and keep your H1B status. However,
Yeah,
in the current setting, I mean, the better way to handle this is to go ahead with the AB5 based EAD and use that to run your business and attend your job. You have an I-797 approved H1B with an I-94
yeah,
in it.
yeah.
Um,
Be,
and you can get a stamp easily in Canada. Whenever you can get a stamp
if you want to
now.
get back
You
on,
can get
yeah,
a stamp now before you even do that.
yeah,
And I think that goes back to his previous question: can he do the stamp here in the U.S.?
yeah,
That which needs to be looked at carefully. But if you're able to get a stamp, whether by the pilot program that they're stamping you in the country, or by going abroad for Canada and coming back,
best of both worlds, I
then you
guess.
can just abandon this H1B, use
Yeah.
the EAD, get the EB5 going. Anytime you feel you need to get back on the H1B, there's a simple departure and coming back.
Yeah, the thing that interests me is I would want to get to work, because here's what stresses me out as an immigration attorney, somebody who has a EB5 case, is you have to go out there and you have to create at least 10 jobs for U.S. workers, and you can start doing that as soon as you have that. You can work for that business, and I guess, well, why would you not want to get started on that, meeting that requirement earlier? Because as the hypothetical attorney who would file that EB-5, I can control the case I put out the door for you, whether you meet the financial requirements for EB-5. But what I can't control is whether or not your company can create those jobs within the EB-5 timeframe. And getting started as early as possible is really kind of where I would want to be. You know?
Good answer.
Yeah. So let's somebody sort of back in the topic of the Visa Bulletin again from
Mhm.
Rod's channel. EB2 rest of the world moved by 2 weeks in the February Visa Bulletin. Do you think it's a norm that the Visa Bulletin moves by 2 weeks on any average month for EB2 rest of the world, waiting for March 15th, 2023 to be current? Well, Sam, you were just out there, burrowing around in the recent Visa Bulletins. Um, I take Raj. I take the position that as soon as you start saying, yes, that's what the Visa Bulletin's going to do, it's going to buck you off it, to use a metaphor. You know,
There's no such thing as the norm in the Visa Bulletin. They meet every month, and the USCIS provide data. The
yeah,
State Department has their own data. They put them in a martini shaker. They shake it, put some ice on it, pour it in a glass, and you get the new Visa Bulletin. It is incredibly unscientific, and the court have supported this unscientific
yeah,
approach.
yeah,
As long as you're able to meet significantly or substantially, I should say, the number of visas issued yearly per the Congressional Act.
yeah.
They don't really require that you're accurate in these monthly
Yeah.
releases.
They're more concerned. Yeah, it's more. They give the visas. The visas are given away. That's what matters most. Who's in exactly your place in line, even though it doesn't really
So
matter.
it's not the norm to move two
Yeah.
weeks. It's all based on supply and demand.
I guess the practical question here from Rad's channel is his, when is my priority date going to become current? His EB2 rest of the world dates for filing for the February Visa Bulletin are at 15th of February 2023, being a month off from where Raj channel is,
Yeah,
where his priority date is.
which tells me again in our prediction that we're looking at beyond October.
That doesn't seem crazy to me. October is not really that far away. It's just, it's November, December, January, February.
One
We've
month,
already had, it's getting pretty darn
9 months.
close.
Yeah.
Yeah, yeah, yeah. Some from Chandabanu Gaur. Uh, ooh. Uh, Hello, guys. Do you think EB1 India will move forward aggressively for the remaining of the year, reaching May end of 2022 filing date? So we will go look at that Visa Bulletin once again, and
So it depends on which. There's four different categories. Oh, EB1, not EB5.
EB1 India,
Yeah.
yeah,
So EB1 has been moving forward because the
rest
rest
of
of
the
the
world,
world is
yeah,
current, and yes, it will move. It will move, but I don't know how aggressive, but it will most certainly move forward.
I would
Uh,
well, I would say it'll definitely move better than EB2 or EB3. Would you agree with that, Sam?
yes, yes, and I'm surprised it didn't move this month with the uh, chargeability of rest of the world being current.
Current, yeah.
It
You would
makes
think
no
that should
sense.
cause overflow. Well, I'm thinking back.
I think they do it quarterly. I
Yeah.
think the cross
Well, yeah.
flow is done quarterly. It's not done monthly. So they moved it last month, I believe. So they're gonna wait
Yeah, a
until
pretty big jump as I
yeah.
recall.
They're
Yeah.
not gonna move. They're not gonna do cross flow every month. They're gonna
Yeah.
do it every quarter,
Yeah.
which makes sense. But
However,
is mhm.
go ahead. EB1 India being C on the Visa Bulletin current was a sort of a phenomenon that happened for a little while during the times the COVID pandemic really, but I have to think back, and now I want to kind of check prior Visa Bulletins. Wasn't for a long time, EB1 India still backlogged. And what I'm going to do just to sort of check my math on that is go back to, I don't know, January 2020 and just see where it was. January 2020 EB1 India was final action dates was, yeah. Here's where I kind of look down. January 2020, right before COVID, EB1 final action dates for India were in January of 2015. You know,
Yeah, but
pretty darn backlogged.
yeah, but there's more than one moving part to
Yeah,
the EB1 India. You have the cross flow that is going to happen every
yeah,
quarter, but also you have the EB2s who are filing and moving to EB1s with earlier priority dates,
yeah,
and these guys will get more, priority. Let's say 2015, 2014 priority date, and they're filing in the EB1 now. These people file for adjustment status immediately
yeah.
under the current date. So there could be cross flow,
Oh yeah.
but at the same time, there may not be forward movement.
Well, yeah, I would point out, as I'm the guy staring at the January 2020 Visa Bulletin, just as a point of reference, EB1 rest of the world was not current at this time. It was back in October 2018, so being about almost a year and a half delay right then. Whereas right now we have the benefit of EB1 rest of the world being current, which, as you said, creates cross flow. I
Yeah.
guess it's been a while. I guess the new norm right now definitely seems to be EB1 rest of the world current, and that only stands to benefit India and eventually China in terms of backlog, which is nice.
Yes. And just kind of a side note, obviously, with the government not shutting down, we continue to see normal adjudication of all cases. So there's no. I think we got an extension until March and see what happens. So
Yeah,
that's a good news.
yeah.
All
Uh,
right, next one, Brian.
yeah, I gotta go back to my oh sky limit. How to schedule a private consultation with either one of you. So I will. We have a very visible internet presence by virtue of the fact that obviously we are right here on YouTube, and I will put up that contact information for anybody who is interested.
Yeah, so all you have to do is just send an email and request a consultation. You will receive an email back with a simple link to it allows you to put in the facts, what you need to do. You can upload documents in it, and then you submit it, and then you'll be scheduled in typically with as soon as possible, and we'll talk to you.
Yeah, yeah, yeah. So, all right. Well, another frequent viewer here, Emily Marshall. With EB3, rest of the world, now 5 months between the filing date and the final action date with 7 more bulletins. Do you see the filing date chart more before they only start using chart A? Yeah, this is a question I think we've seen from Emily in the past. One thing I didn't bring up here, we checked this just before going live today. It's what dates, what charts are they accepting? USCIS is accepting the dates for filing for February of 2024, and it's historically it's been at the beginning of the fiscal year they'll accept the dates for filing, and maybe in the last couple of years we've seen it through the end of the calendar year, and after that all bets are off, and we are here in getting dates for filing into February. Pretty nice. Um, me, we kind of get the impression, this is our reading of the pulse of the Visa Bulletin, that they're trying to be a little bit more friendly, maybe. Do you tend to agree with that, Sam? As they can be?
Well, two things. One, yes, absolutely. But the other thing is, I think the gap between dates for filing and final action date is shrinking,
Yeah.
and therefore it's really not significant enough for them to upset people.
Yeah.
So they're just keeping it because really these windows are narrow now.
Yeah, I don't see. So I think I have to agree with what you were saying earlier, Sam. That again, our present theory is that the dates should shrink, and eventually at the beginning of the fiscal year, they should flap out. They should flap go. The difference should be shrinking, and then at the beginning of the fiscal year, it goes out and it shrinks. It plays an immigration accordion every year, but I'll wait until the April Visa Bulletin to see whether they actually move
It's
those
hard.
dates.
Yeah, I mean, but again, this new administration can have a different view of how to use that
Yeah,
because
that's very true.
yeah. I mean, they could in the second half of the year they start pushing into the following fiscal year by
Yeah,
moving that the filing date a little bit forward to allow for that buffer or that
yeah.
volume of cases. But
Make sure.
I don't think they have a volume of case problem. I mean, obviously, when they've created the Visa Bulletin and then they came out with the dates for filing, it was the idea that we need to have a in the pipeline cases we're working on. But
Yeah.
since COVID and the backlog has been so big, their pipeline has been full.
Yeah.
Therefore, the benefit for that that the dates for filing used to provide is no longer there. They have
Yeah.
tons of cases, so
Well,
it's not being taken seriously. I don't
yeah,
think.
and you point out something, make a great point, Sam. I mean, there's that FAQ, the employment-based adjustment FAQ, saying for India we have cases in our hands, kingdom come,
Yeah,
for the next several years, years worth.
yeah.
It seems a little bit illogical that they're accepting dates for filing at all. Why would we take people's cases early when shouldn't we be giving? I guess yeah, that's why should we be taking people before their priority date's current if there's already people who
The,
already have their cases in progress. We can give away those visas faster,
well, yes, but the answer to that is very simple in my mind. The dates for filing isn't moving, and since they've accepted it earlier,
Yeah.
and that these dates are not moving, they might as well keep accepting them because they've taken every case up
Yeah.
to the dates for filing thus
Yeah.
far.
And,
Anyways,
you're right. There shouldn't
there's
be.
no movement on that
You're
date,
right.
so they can take it. So what the
There
heck?
shouldn't
They're
be
not doing.
there
Yeah.
shouldn't be that many new cases coming in because they've already taken cases from
Yes.
June of 2012.
Yeah.
The
So
vast majority of them.
might as well look good, look
Yeah.
good,
Yeah. Yeah.
and say, "Oh, we're taking dates for filing," but there's no cases to file.
Yeah. Yeah. Another bit of a follow up here from Emily. Is the last quarter limit hold on visa numbers that DOS spoke of uh, about the October visa?
Is
About the
this the
October visa.
last quarter limit hold on visa number that?
So in one of the visa bulletins recently, they spoke about quarterly limitations on visa issuances. I think that's what Emily is.
Well, next month is going to be one quarter, and then that will be
Well,
March, then June, right?
no,
Then
I think it's
June
April and
is
July.
April and July.
Yeah, yeah,
April and July.
because July would
Yeah.
be July, August, September, and that's the end of the fiscal year. Yeah,
Okay.
yeah. So yeah,
Okay. So there'll be two more.
yeah,
There's two more serious look at the visa bulletin numbers,
yeah,
in which a more drastic movement may happen.
yeah.
One is, as Brian
A-
said, April,
April, yeah,
and then July.
yeah,
Yes.
yeah. Major, yeah, yeah, yeah. So yeah. Okay. Well, Sam. I was talking about the very popular idea of a very popular June priority date, but I can't help but notice that this person here, Mithun, is the second person who's had an August 2nd of August 2012 priority date. And if I wanted to opine more on where the most priority date density is, Sam, I would say probably in June, right? But also August, September. Why? Because the absolute minimum amount of time they can issue you a prevailing wage for in a perm case is 3 months, right? And let's say hypothetically, if you get prevailing wages in June of a year, the prevailing wage data expires in the month of June. The long story short is prevailing wages gotten from in June; those are going to be valid through July, August, September, right? 3 months. Meaning, I would bet there's a lot of Well, I know there's a lot of perm filing around June, July, August, September because there are forced filing deadlines in there, and I can't
Well,
help pointing these things out, Sam. Tell me if they're incredibly boring factoids to point out because I love bringing them up. Apparently,
I'm staring at my crystal balls.
yeah,
I got a small one. No, this is a big one,
yeah,
and a small one.
yeah,
These are magnifying glasses
yeah,
because sometimes I like to look at the fine print. I guess that's the business of being a lawyer, right? So looking at the fine print of what Brian said in my magnification, I would say it's a respectfully a speculation because what happened and how the prevailing wages were handed back in 2012 is something is beyond my ability to remember. I think back then they were handing them a lot quicker than that
they're
time.
handing them quicker, but still with the
You
same
get the 6 day.
deadlines.
You get the
Deadlines,
6 day. Yeah.
yeah,
Well, at least today, August 2nd, 2012, is the most important day, the most
yeah.
concentrated day.
So the bottom line is, I'm sure Mithun knows that the dates for filing for, I'm going to presume, yeah, in India because he says India, dates for filing India EB3 are 2nd of August 2012, and until we see that Visa Bulletin and we see whether it's possible that they move the dates for filing in the middle of the fiscal year like this, we kind of are left with the impression that maybe it's a next fiscal year sort of thing. Even though his date is getting pretty darn close, it's about a month and a couple days off. Uh, let's look at the April Visa Bulletin. That will be a real interesting one for you, I think.
Yeah.
Yeah,
For some reason, I have a feeling that the dates for filing a chart is a date that the State Department would love to get rid of,
yeah. Why is
uh,
that?
because it no longer serves the purpose. So people don't may not remember, but Visa Bolton had only one chart, which is the final action date,
Yeah,
and that's it. And life was simple, hard, simple. Then they came out with this final with the dates for filing, where USCIS and the Department did not see eye to eye, and they continued because it provided some benefit to the consulates. But for the last 2 or 3 years, that benefit to the consulate is gone. There's no more benefit for dates for filing because the backlog is severe, such that the dates for filing concept is really of no benefit,
yeah.
really. But we see certain laws being built around it. Where like the Child Status
The
Protection Act
CSPA
now is
laws.
relying
Yeah,
on this, and things building. So getting rid of it is more difficult. So they leave it alone.
yeah,
But
yeah,
August 2nd, 2012, based on this superfluous, completely worthless dates for filing chart that the State Department gives us every month,
not for
tells
the
us that yeah,
yeah,
it tells us that at least they're thinking it's not this year.
not within the
But
foreseeable future. Yeah,
yeah,
yeah.
but you never know.
We're still Sam. I had a very funny pop up just come up on my computer. I'm on the Department of State Visa Bulletin website, and they say, "Tell us about your experience with travel.state.gov. Using this website has increased my trust in the Department of State. Strongly agree, ranging down to strongly disagree." I don't know what to say about that. I like that they're asking me for my feedback, but I can't say that the Visa Bulletin has ever given me much trust in the Department of State.
Yeah, they're not giving you the real option that you should choose, which is I'm totally confused.
Yeah, yeah. That is the real answer
Yes.
there.
All right. So
Yeah,
let's take one or two more as we're
yeah,
running out of time.
yeah. From KK with which looks to be an interesting question. Sam, go ahead.
I have a special needs son, a U.S. citizen. If I apply for state offered supplementary medical aid, will it be counted as using government benefits? Will it increase an issue for my green card citizenship? Thank you. Um, that's an excellent question.
Yeah,
One that I honestly would need to research before I can answer for your benefits.
yeah,
Your son is a U.S. citizen, clearly is entitled to that, but he is the guardian, and I'm breaking up the case, and he has a financial responsibility towards his son,
yeah,
and therefore, with the supplementary medical aid the son receiving be imputed to the parent in terms of meeting or not meeting the any financial um, public charge issues?
yeah,
And that's the question. And the answer is probably not something that you will find easily because it's something that probably has never been resolved. I doubt.
yeah,
But there may be some in the fine print, some details that can answer that question. So that really need to be researched. I don't have an answer off the top of my head, but it's an excellent question that KK should seek the assistance of an attorney to get an answer to that.
yeah. I
And
mean,
it may be in the regulations.
yeah. I mean,
Um,
one thing.
that's all in the fine print, I guess.
One thing that I would point out is, I used to sort of take crystal ball. I used to
Mhm.
take sort of public charge for granted, right? And then 20 what when was it? Like, when it come well the last administration came along, right? And public charge became a far more complex issue. And what is the answer now? I think can potentially change based upon the way they interpret the charge rules as
Mhm.
well, or even change them in the future, which is something that I guess never take immigration stuff for granted. But public charge is something where we've seen a lot more scrutiny and excitement about it in the last couple of years than I'm really used to.
So I'm quickly in the Visa Bulletin. And there is a whole section about receipt of public charge benefit by children. So this is an issue that has been addressed.
Oh, there you go.
Supplemental, special supplemental nutrition program for women, infants, and children. That's one section. So that needs to be looked at. And there's 482 reference to children in the Federal Register on public
Oh, dear.
charge. So a quick look at the law, and here's I think there is an executive summary,
Well,
and it applies to certain context. So clearly, the answer is available with a little bit of legal research.
yeah, good.
Yeah.
Well, maybe we'll make this next one our last questions, and call it a night here. Some good hypotheticals from HF. Part 1: employment-based green card is approved. I like to think and hope that's your employment-based green card, HF. Would USCIS cancel valid H1? If yes, would a notification is sent to an employer or an attorney who filed H1 named in G28? So for me, Sam, I'd say my answer to this is who cares? Because I don't think USCIS does on this matter. From the individual's perspective, HF's perspective, if you've been granted a green card, I wouldn't personally worry about your H1 through an employer. Is my short answer. Now, if you're the I would say, what do you think about should somebody tell their employer that their H1 their green card's been approved, their employment-based green card's been approved, Sam?
So you say who cares, but that doesn't answer the question. The question is no, they don't send a notice.
Well, USCIS doesn't do it for sure.
Yeah. Yes. Who filed the H1B or the G28, because it's superfluous, irrelevant. Because it disappeared. There's nothing there to approve, to withdraw. It doesn't exist anymore.
Yeah. I guess if I were the employer, I'd want to know so I can withdraw the H1B LCA, for example, to clean up their public access files. But beyond that, maybe it's good for the employer to know that you're not subject to the H1B, relocation and salary requirements as well. You have, but also, I mean, you should notify your employer because you're definitely going to be subject to the pay requirements of your green card application as well. It's worth it talking to your employer about that. There's a part 2 for HF, and this is going to probably be the end of it here. And here's the question. Part 2: my green card is with previous employer, currently working for new sponsored H1 employer. If H1 is canceled after approval of my GC, would my H1 employment or attorney get an H1 cancellation notification? And for me, Sam, I don't think I've ever gotten an H1B. It would be a noir for the purposes of somebody getting a green card.
So the only time USCIS will deny an H1B is if it's pending and the green card was issued.
Yeah,
they have an open case. They have to act on it. So they will say we will deny because we have no other way of doing anything else. And then they'll deny the case.
Yeah, I think maybe I have seen that scenario with somebody with a pending H1B extension or something gets that denied because, well, you're not eligible because you're a permanent resident. But
yes.
Again, it's the employer. The employer probably has an interest in knowing that your green card has been approved, such that they can withdraw your H1B. And I guess your employer is required to withdraw H1Bs that aren't there. But for you personally, it's not really your concern. It's the responsibility of the employer to take action on that. As the bottom line.
Yes. Yeah. And before we end, back to our public charge question, friend. There is expansive discussion about public charge to pregnant women and children and U.S. citizen children in the most recent Federal Register, and the treatment of them that has provided some protection. So it looks positive. It clearly needs to be looked at by an attorney to know exactly what you've requested. It looks very positive, but it's there. You just need an attorney to help you out getting the answer that you're looking for. Just so we've given some answer to the question before that. And for the gentleman who got their green card, congratulations. Don't worry about the H1B. The heck with it. It's part of your history.
Nobody, they don't care anymore. And if if your employer withdraws it, Who cares? And if they never withdraw it, well, who cares as well? It'll go away eventually when it expires. It doesn't matter either way to me.
And with that, we end today's session. Thank you guys for listening to us. 6 o'clock Eastern time every Monday. We will answer your questions and come out with some analysis on a topic that is happening. And until Monday, 6 o'clock, you guys have a fantastic rest of the week.